We are going to get started in just a second because I see Kelly getting ready at the bar. Oh, she is just on top of things. Let's give a round of applause for Kelly, who's been running the show tonight. Thank you. She's been fantastic getting everything set up and serving you all these delicious drinks that you're enjoying. But I'm Kristen Tanner. I'm the programs manager here at Innovate Marquette SmartZone. And welcome to our second installment of Tech Talks, everyone. So if this is your first Innovate Marquette event, welcome. Hope to see you back here again soon. Just wanted to tell you a little bit more about us before we kind of dive into the main reason that we're here today. So Innovate Marquette is one of 21 smart zones located around the state, and really what's important to know is we're a resource to our community. We're a resource right here in Marquette that helps local innovators, entrepreneurs, high-tech startups, all of you who are in this room and all these creative minds. We are a resource to you and want to help you. So if that's your biggest takeaway from tonight, just know that our team is here to help. What I want to really kind of kick off before the main reason we're here and hearing from Brian Janowski is really just letting you know that we are right across the street. Hopefully you all have come to our open house recently. We are downtown Marquette. We're literally right behind us at the ORDOC right now, so you can come find us, walk in our door, visit our website, but really just want to let you know we have a very supportive team that is here to help guide you all through your entrepreneurial journeys. So enough about us, have some few housekeeping items before we really dive in. Hopefully you all got your program. I know our fantastic Kylie and Lauren were checking you all in. So in your program there's a QR code. We'd love to hear from you about what you think of tonight's event. So after the event, scan the QR code and let us know your thoughts. And as I mentioned, this is a series. Tech Talks is an event series. This is our second installment. So as you might expect, we have more coming up, folks. Our next one after tonight is after the holidays. It's January 12th. We'll be at the Peter White Public Library. Ben Vandenbroek will be talking about 3D printing, so another really interesting topic. And I also just wanted to give another shout out to Kelly and Andy, the whole ORDOC crew, for hosting us tonight. It's a beautiful space. We're spoiled because it's literally in our backyard, but we're really excited to just be here and gather with all of you. And of course, tonight's event wouldn't be possible without the support of all of our sponsors. So Innovate Marquette SmartZone programs and services are made possible in part through ongoing support from the Michigan Economic Development Corporation, or as you might commonly know them, MEDC, as well as the City of Marquette. The MEDC collaborates with more than 100 economic development partners to assist businesses of all sizes with their growth and operational strategies, from financial funding to connection opportunities. This partnership is really instrumental in recognizing Marquette as Michigan's next tech and innovation hub. And we truly believe that. So really excited for all the support we get from the state there and all of you who help fuel this community. But now, for the reason we're really here tonight, I am so excited to welcome and introduce tonight's special guest, Brian Janowski. His educational background and professional background spans across mechanical engineering and physical therapy, so it's no surprise that Brian is curious about how things work. From exercise equipment to medical devices, Brian has experience designing products that make our lives easier, and I've seen this firsthand. He has a true entrepreneurial spirit and holds over 50 patents. Let that sink in. 50 patents, guys. When he's not busy working on his own inventions, he helps folks in our community with their own ideas. If you've come through our program, you've probably worked with Brian in the past. With over 20 years of experience as a patent agent, it goes without saying that he is an expert in this topic. You guys are in for a treat tonight, but I could go on and on about your impressive resume, Brian, but really what I think is worth mentioning is that you are such an incredibly kind and thoughtful person. Over the past 2 years that I've been with the organization, I've really had the pleasure of getting to know Brian better, and he is just one of a kind, just a wonderful human being. So I am so thrilled, and let's all join me in giving him a warm welcome to Brian Janowski.
Well, thank you, Kristen. I didn't expect to be choked up before I got up here, but I really appreciate that and all the kind comments. And I also just want to say, before I even get started, is thank you to everyone at the SmartZone. It's a real pleasure working with everybody. It's just, it's really what drives me, gets me excited. I love working with entrepreneurs, and as my wife will attest, I have a hard time shutting off sometimes, but it's really, enthusiasm for it. So, but thanks for everyone, all the students. I love your energy, your ideas. Joe, Dave, Kristen, just everyone, really appreciate it. So, all right. So Kristen went over much of this. So I basically started off as a physical therapist and ended up, as I was treating patients, thinking a lot about, okay, what are the machines that I would want to invent to work with these patients? And so I'm, at the time I was single, I thought, well, I'll just get an engineering degree, why not? And then I'm like, well, I'll probably want to patent these things, so I'll become a patent agent. And so that sort of was the pathway that I moved into all of this. And my wife is from Marquette. I've always enjoyed Marquette and actually worked at Pioneer Surgical for a while, but I'll get into more of that a little bit later on. So let me just start by talking about intellectual property. And it's sort of this term that really a lot of people are confused about. What exactly is intellectual property? And when we talk about intellectual property, we're actually looking at mainly 4 different areas: patents, trademarks, copyrights, and trade secrets. So when you're talking about patents, it's basically a right that's given to exclude others from making, using, or selling an invention for a specific time period, okay? And what that gives you is it limits the competition. So if you have an invention, it basically prevents others from entering that space to compete against your product for a select period of time. And as a patent agent, that's what I deal with. These other ones, I've had a fair amount of experience in, but it's not the crux of my business. In terms of trademarks, we're talking about symbols, a slogan, logo, something like that. That essentially identifies they call it a source identifier for your product, okay? Those are trademarks. Copyrights tend to have to do with, say, books or movies or things like that. And when we talk about trade secrets, basically those are a trade secret. Most people think of like Coca-Cola, for example. The recipe for Coke, they didn't put that in the patent someplace, how to make that. But what they did is they went through very specific processes for how to keep that recipe secret. So like their documents might have to say confidential. And there's all these different things that they have to do to make sure that they keep it a trade secret. And Coca-Cola has done that for a long time. And so before I get going, I just want to sort of set the stage. I understand that the SmartZone is not using this growth wheel approach anymore, but I want to point out that when we talk about patents, sometimes people have this idea that, well, if I can get a patent on my idea, that's all I need. Here come the the money. Here comes the money. It doesn't work like that. And if you look at this, I think is a good graphic to say, these are all the things involved with making a business go. And actually, when I look at it, patents really, I don't see it any particular place here. It probably fits into the business idea, probably fits into legal issues, but there's a lot more actually making an idea go and to begin earning money from that idea, okay? So I just want to reinforce the whole fact that it really is a myth that a patent is sort of my ticket to success. There's a lot more to that. On the flip side of that, or part of that, is some people will argue, you know what, I don't want to deal with patents, and they have the approach of, well, if I'm first to market, and if I can dominate that market, and if my brand can really stand out, then I can capture the market, and I don't need to rely on patents. And that's another valid approach that people use. So I just want to point those things out before we get started. Also, if people have questions, go ahead and ask, and I'm happy to stop. Yes?
Hey, Brian, you brought up the example of Coca-Cola. Why wouldn't Coca-Cola want to patent their secret formula?
I think you know the answer to that. But no, actually, when you file a patent, it eventually becomes published. You have to remember that the reason that the whole patent office evolved was they're trying to get your technology, you to disclose your technology to the public so that the United States, for example, can become more advanced, okay? And so what they do is they say, you disclose your technology, we'll give you the exclusive rights to that for, say about 20 years, but then anyone can use it, okay? Coca-Cola says, we want to have Coca-Cola for more than 20 years, and we want to be the exclusive one that has that formula. So that's the reason why they wouldn't patent it, and they would go down the trade secret route. So this morning at morning basketball, Joe Theo says, you know what, you really need to talk about your entrepreneurial journey a little bit. So I'm like, oh, I thought this presentation was done. So anyway, I added a few slides. I'll try not to spend too much time on this. But as I mentioned, I started out as a physical therapist, and I was working with some of my classmates. And one of the first things that we did was we started a business called Absolute Rehab Video. And Absolute Rehab Video was basically making rehabilitation videotapes for specific diagnosis. So if you had, say, a rotator cuff tear, what are the specific exercise programs that you would want to be led through? And so that was the first business. We were a little before our time. It was actually before digital. So everything that we were doing was on videotape, and ultimately it was a little too early because our videotapes were wearing out, breaking down and stuff, and it required a much bigger investment to get past that. But during that time, I started looking at going to engineering school, and I ran into this, I was looking for a way to get it funded. And I bring this up just for a lot of the students out here, in that the way I got my grad school funded was, I don't know if you guys remember the Chuck Norris and Christy Brinkley commercials, like, that went on forever, infomercials. Well, I basically wrote like 100 different companies and said, hey, I want to design products. How about if I do it for you? And in exchange for helping me with grad school. So it turns out that I had used this Total Gym in the clinic, and Total Gym works completely by gravity. And so to get the lowest resistance, this is on the lowest incline. It's the flattest. And that's what we would use for our most involved patients, the ones that were the weakest. Problem is they had trouble getting down low to that low incline. And so basically Total Gym sponsored my graduate school to design them an apparatus that essentially lifted this Total Gym in space and then inclined it, yet still had access for people to exercise on it. So that was kind of the initial start that I got into this. And I would recommend this to all the students out here, is really don't be afraid to call up companies and say, you know what, I have an enthusiasm for X, and I want to design a product for you. And you want to pay me to do that? And you know, it works. In this particular case, I should mention, I think I sent out 100 letters. I had like 6 or 7 different companies that were willing to sponsor my grad school experience. So after Total Gym, I formed a company called Innovative Biodesigns. And again, by going to a trade show, I run into this company called Balanced Body. And Balanced Body, and when I went to this trade show, I had business cards in one hand, looking to design a product for somebody, a resume in the other, trying to find a job for myself. And Balanced Body said, hey, these are the Pilates reformer machines that we sell. But at that time, they were working with Bally's Fitness, which is a fitness company that's across the United States. They have fitness facilities. We want to take something like this, but be able to roll these machines into a room, spread them out into an aerobic studio, and perform these Pilates reformer exercise classes. And so basically, I was able to work with them. At the time, I thought it was a great deal. They basically paid me $15,000 and a seat of SolidWorks, and I designed this machine for them. It turns out the machine is still being sold today, like 22 years later, and it's pretty popular with athletes. That's LeBron up there, and this is Lady Gaga. And it's kind of fun to see, you know, these people using it out in the field. After I graduated from Michigan Tech, I went to Pioneer Surgical Technology, which is now Resolve Medical, and basically helped innovate an array of orthopedic implants with pedicle screws, bone plates, all kinds of things, artificial discs, things like that. And also managed their litigation matters. And then after they basically went up for sale, they got rid of a whole layer of us. So in 2012, I ended up being without a job, but we had a lot of family ties here. So basically, I started Device Patent to serve the community and keep our family here in Marquette. So, and that's what I do now, is basically secure patents for people, entrepreneurs in the community. In 2020, I basically started this Janowski, and it's essentially the idea of, okay, I can design products, I can patent products, let's get some of these products going and out on the market. So, so there's a few of these. One, Free Motion. Dave was telling me this is basically a device that supports like a keyboard or a tablet right on your waist, so you can kind of freely move while you're controlling your computer. I haven't seen the most recent prototype of it, but I hear it's pretty amazing, so really excited. And again, accolades to Innovate Marquette SmartZone, because they have some really good people working on this stuff. So another project I'm working on and have, well, essentially what happened is a few years ago, about 7 years ago, I had learned of a company that, well, it's actually research coming out of Michigan State University, which are coatings that are clear, transparent, that collect solar energy and turn it into electricity. What I found interesting was they talked a lot about the coating, but they didn't talk about what they were going to do with it. Well, that was the gap that I filled, was I started designing patents or devices having to do with solar windows, electrochromatic windows, basically windows that would you could adjust so that they darken, and they're powered by these coatings that are on the window themselves. Some work in orthopedic implants, a cardio reformer for the Pilates, which is another accessory that's basically going to expand its use. And probably the most effort we're going into now is this product called Hitch Hatchet, which is essentially this little device that slides into the hitch receiver of your vehicle. You put a log on top of it, you smack it with a mallet or something like that, and you get nice pieces of kindling that come off the side of it. So just briefly, I want to talk about, this is a product that we've been working on licensing, and it's been kind of interesting because there's a question of, well, how do you find these people that you connect with, and how do you find people that can distribute it for us. So what I have found useful is working through LinkedIn. I've been basically reaching out to people, C-level people at these companies, and saying, hey, I have disruptive technology. I think you guys should take a look at it. Reach out, let's be friends, and let's talk about it. And that's been a very good experience. We've been on a few calls so far with different companies in the outdoor industry and in the hitch and towing industry. And we're making progress. We just haven't sealed any deals yet. So, Joe.
When you're on those calls, Brian, what's one of the first questions they ask you about products like this?
Well, the first question they ask is, do you have a patent on it? And that's a really good point, is that when I was at Pioneer Surgical, I was in a lot of the meetings because I was the sort of the welcoming committee for surgeons and other people that came in with their business ideas or their inventions that they wanted to see as an implant or implant tool or something like that. In all of those cases, in every single case, it was like, okay, what kind of intellectual property do you have, or what can we get? And so, I don't want to paint a picture as to that being the only way you can go about it, but it's almost always the first thing that's asked. So, yes?
Liability insurance, where does that come into play when designing a product?
That's not part of my expertise. I will say that in terms of liability, I know it's readily available. I can tell you for this product, for example, I don't remember the exact amount. I thought it was like 40 cents per unit, that I could get liability insurance on it. But that's really about all I know about it.
Okay, that's one of the first questions that you asked with marketing.
Sure. Okay. So the other thing I want to mention is just, I think another great place is trade shows. If you can get out to trade shows for your particular industry, for your invention, it's really a great place to network and find people that are doing similar things or can actually give you a lot of feedback. You know, when I show you this, do you get excited about it or do you think it's stupid? You know, is this something you would buy? Would you try it? What's wrong with it? And you just get a ton of feedback on your product, but also, you know, it helps you make connections as to, okay, where can I sell this? And, you know, what are my sales channels that I can bring this? So, anyway, I would really suggest that.
But now, going to these trade shows and stuff, you know, do you already have the patent in hand before you go to the trade shows? So you're not like, oh, look at this wonderful thing I've got.
Right. So what I would suggest is, and I'll get into this a little bit more later, but at least having like a provisional patent application filed. And, you know, just to, it establishes a date and it establishes, you know, what you knew at that particular date.
Okay.
It doesn't necessarily have to be perfect. I mean, it has to be clear, but it doesn't have to be perfect.
Okay.
All right, I have myself a little reminder here. This is a call out to my wife, Laura, who, as you can see, my path through this, I easily get distracted with a lot of these projects. And, you know, this is the type of stuff that can sink a bad relationship. And, you know, I appreciate her sticking with me and, you know, being there for me throughout this whole process. So, all right. So why consider patenting? So patents provide for a period of time, which is typically about 20 years from the date of filing. In the country, the patent is awarded the right to exclude others from making, using, or selling the patented invention. Okay, so it essentially provides a legal recourse against competition in the market until the patent expires. Okay, any questions about that? In addition, it really gives startups a boost. It creates confidence and excitement about the invention. So if you're a startup and you're going out to seek investment, the patent filing, you know, it gives a level of seriousness about your project. Again, as Joe, when he asked this question, you know, people want to know that you're serious, that you are coming to them for investment, but hey, they want to make sure it's protected. They want to make sure that, you know, they're not going to dump a bunch of money and then find, you know, 20 different companies making that particular product, you know, within a few months or something like that. So, and also, if you watch Shark Tank, you know, it's interesting listening to how they approach a lot of these investments. And for projects, they either look for a really good market saturation where someone's brand is really well recognized, but they're almost always asking also you know, do you have patent coverage for this? And what kind of patents, how many, etc. Again, as we mentioned earlier, if you're going to license or want to outright sell your product, you know, the whole intellectual property portfolio, it's something that's really helpful in that process. And then also you'll see that customers often feel purchasing is something special. You know, when you go to the marketplace and you see, you know, 20 different manufacturers of one product, you know, then it makes it hard to choose. But by having a little bit of protection, you know, limiting others from your space, it really helps customers focus and say, hey, this is the guy that's really, or gal that really makes the, I don't know, whatever product, Hitch Hatchet or whatever it may be. So a lot of people like the original. Yes?
Brian, one other thing too that we see, I think maybe you could add this a little bit is, when you're developing an property, that's great, right? You've got this patent, you've got this idea, you've got this concept that you want to patent. But a lot of times it takes a long-term development to actually bring that product to market, and that's when it becomes real valuable. If you have IP and you're working with a partner, and the partner will help you actually develop that product. If you have IP, it's much more likely that they're gonna spend NRE dollars, non-refundable engineering dollars, or engineering towards actually producing that product and getting it out in the marketplace than they would if you didn't. Right. I think that's another benefit of intellectual property is that a lot of times it takes a pretty big effort to actually get a product to be invented to the marketplace, and to be able to effectively do that in the research and development and engineering. To have a patent in place, it's much more likely that a company is going to support you with those engineering dollars to get it to commercialization if you do have it. Especially more complex ideas, right?
Right. Yeah. When I was speaking earlier about the orthopedic, I have a patent on a spinal implant device that, I went the LinkedIn route and asked all kinds of different people in that industry, what do you think about this? And they all say, oh, this is great. But no one really knows what to do with it because it is so complex in the medical device space that it's something that I don't know that I want to pursue. So, I'm sorry, there was a question here?
Yeah, can you patent a process?
Yes. Yep.
How is that any different from a product?
Actually, I will get to that in a lot more detail in later slides. Yes?
How about the cost of somebody infringing on your patent and protecting it? And who's responsible and what gets involved? Have you ever had experience in that?
Well, it's not cheap. And that's where I will also address that a little bit later on. But
Is there a percentage that they can change your idea and get patent on their own to spin off your idea?
well, all of that comes down to how the claims are written. Okay, so that's where it's real critical as to how your claims are written to
Protect that.
protect from other people making small tweaks to it.
That's why I'm here.
Yep. So you really need to get into the detail and specifics of making sure those claims are drafted correctly. You don't want them too broad, because if they're too broad, it may overlap with some other art that's out there that could invalidate your claim. So what you want is the broadest claims that you possibly can get that are still valid. Okay, so that can be challenging to figure that out. So, if I don't answer those questions as we go through these, make sure you ask me again, okay? Let's see. All right. So a little bit about the process when you're working with either a patent agent or a patent attorney. And also just briefly, the difference between patent agent and patent attorney. We both sit for the same exam, the patent bar exam. The attorneys, though, if you had litigation where someone was, say, infringing on your product or you're infringing on someone else's, you would go to the attorney to take legal action. Okay, but as far as drafting and prosecuting patents, we do the exact same thing. All right. So basically, as we work together, we start off with just an introduction, and the first thing I would do is some sort of conflict check. So I would ask, generally, what is your invention about? And I would think about, other inventions that I have, just to make sure it's not in the exact same space, and I don't want to be in a position where I have sort of conflicting work with two different clients. Then there's an engagement letter, which basically lays out the terms of what our legal relationship is as we go through this patent drafting and prosecution. Through the patent drafting and prosecution exercise. And then the inventor will disclose the invention. And that comes in all kinds of different forms. Sometimes all I'll get is maybe a napkin sketch, okay, and clients really won't have an idea of, okay, what do I do with this? And I'll either refer them to the Innovate Marquette SmartZone, or I do have a CAD seat, but I try not to do too much of that. But basically, we can help facilitate that invention beyond its initial concepts. And then once I have all the sketches and the background that I need, then I'll start drafting the patent application. And one thing that's important here is that to get patent claims allowed, they have to be very well supported by written text and drawings. Okay. So one of the biggest problems that people have is they'll start prosecuting a patent and they'll go after a particular claim, but then they realize that, gosh, I really didn't flesh out my language well, or that isn't shown in my drawings what I want to claim. So it's really an exercise of making sure that everything that you want to protect is in that disclosure and in those drawings. I like to think of, I use this analogy sometimes, it's a spice rack. And basically, I can have one invention that only uses 5 spices, but for me to think about all the different alternatives, I may start using different spices to make, some great spaghetti sauce, for this spaghetti sauce invention, so to speak. So it's really important to disclose as much about that invention and different alternatives as you can in that patent application. At the same time, you really need to make sure your language is consistent. In one part of the application, you run into problems if you call, say, a chair leg a leg, and then over here you call that a chair strut, but you actually mean the same thing. It introduces a lot of ambiguity, so it's important to really be consistent with your terms. And I like to think of patents. When we talk about intellectual property is sort of like, it's sort of like real estate. So when you think of the globe, and here I have, a layout of, say, some land. And you know how this here is somebody's property. And if you go to the deed, that property will have a description, locating each of these corners of that piece of property. And it defines what that property is. Well, intellectual property is really similar. If you think about the globe being the collection of all the inventions that are possible out there, the claims of your patent is basically a description of that invention that makes up that little cell, okay? So the thing is that when you go after this, your patent can go after this cell, but if you disclose more, it can go after all of these cells. And if you disclose more, it can go after more of this property. And so the thing is that everyone has a limitation of time and money. And you gotta figure out, okay, what's most important to me? What am I gonna go after? And without going too crazy. Now for me, I have an advantage because, I don't have to pay for myself, okay? But, this stuff gets pretty complex and, takes a lot of time. And so you'll find there's decisions as you go forward, how much do I really want to go after? So after we draft the patent claims, then we'll have a client review, and then we'll file the patent application in the U.S. Patent and Trademark Office or other jurisdictions. And when I talk about other jurisdictions, remember that our patents, when I file in the United States, that is for United States coverage. But that same invention, if we want worldwide coverage or Europe or other countries, we have to file either directly in those countries, or there's something called the Patent Cooperation Treaty, which is basically a bridge that allows us to, gives us some time to move into those countries after, I think it's like 18 months afterwards. So, anyway, any question? Yes?
I have one. Let me get a quick time check. That we have about 15 minutes left. I know there's some unanswered questions, but I do have a question.
Sure.
I've worked with you not in a client-agent relationship, so this is all a little new to me. What is, in your mind, like in your experience, the most, I guess, surprising thing that people encounter in working through the patent process? Like the biggest unknown, I guess.
Well, the biggest unknown, and I'll get into this in a little bit, is that when you're doing patent searching, basically your inventiveness has to do with novelty. Okay, and actually I'll get into this in just a moment. But there can be something on a shelf in, Zaire that's public, that may be your same invention that no one knows about, but somehow it may pop up somewhere. And, that's kind of a big surprise, like, oh my gosh, where'd this come from? Okay, so, there's over 11 million patents that are issued. There's many more millions that were filed but were never issued. There's things in catalogs all over the place. It's a humongous task to try to figure out, make sure you're getting everything. So once we file a patent, there's generally two types of patent. There's a provisional patent application, which expires 1 year after filing. It's assigned a filing date. The patent office does a basic check on it to make sure that the most basic information is there. This application is not examined by the patent office. It has low filing fees, typically around $75 to $150. There's minimal form requirements. But the benefit of it is that it secures the invention. It gives the entrepreneur an opportunity to test the market. And they can also add improvements over, if they want to file another provisional within that 1 year period, they can add those improvements to it. And then, but by the end of that year, they have to file the non-provisional patent application. Now, there is the option of just jumping right into a non-provisional. And that works well if you say, hey, I know what my invention is. I'm not going to prove it. I'm not going to change it. I would say, okay, then let's go directly to the non-provisional. Again, you'll get the filing date, requirement check. Once that non-provisional is filed, it usually takes about 1.5 years to 2 years before the patent examiner will actually pick it up and start examining the patent application. The patent examiner will look at prior art submitted by the applicant in what we call an information disclosure statement, and the examiner will have their own patent databases for searching, and so they'll do their own searching to try to determine whether your patent application is valid. And they compare the claims in the patent to the prior art, and then they issue an office action. So when the patent examiner looks at patent application and compares your claims, what are they looking at? It's not like, yeah, I don't really think this is novel. they actually have to come up with prior art to say, you know what, someone else invented that first. And so they're looking at three things. It has to have some sort of utility to it. You know, it can't be just some sort of, you know, I saw this swirl of wind of leaves and I want to patent that swirl or something. It has to actually have some sort of utility. It has to be novel, meaning when they compare it to the prior art, it has to be completely new. And the third thing is obviousness. It has to be unobvious to a person skilled in the art. Okay? Now this is where it becomes a little more challenging sometimes, because when we say it has to be unobvious to a person skilled in art, they may come up with, say, 2 other patents, one from Jones, one from McGillicuddy. McGillicuddy shows, you know, let's say the chair leg, and Jones shows a back of a chair, but no one ever actually combined those before. The examiner could say, in light of the prior art, it would have been obvious for a person skilled in that art to combine those things, okay? And that's where I get in and I say, no, I don't think so. And there's all kinds of legal arguments that I can use. But I basically get into these written battles back and forth. It's like a sort of a mini court case with the patent examiner. We go back and forth and we come to some sort of agreement. Now I may have to amend the claims a little bit, tweak the claims, do different things, but that's essentially what we work towards. So again, all of these things are determined by the patent examiner looking at the prior art. And there's all kinds of things that they can draw from. So it's not a perfect process. I mean, it's kind of overwhelming, but it's really important for you to do as much patent searching as you can, or hire, you know, a patent search firm to do that, so that you really can walk into doing a patent application knowing that you'll probably get it right. And there's some good search engines. I like to use the USPTO, free patents online. Worldwide SpaceNet is a really good one. That's based out of the European Patent Office. And sometimes I use Google. I find Google has some gaps in it. So I really don't use it that much. Any questions? Yes?
How old is the patent system? How long has it been around?
You know, that's a good question. I think it was like really early in the 1800s, but to be honest, I can't give you a super accurate answer on that. Good question. All right, and so there are different types of patent claims. There's method claims, apparatus claims, composition claims, kit claims, software claims, and then design patent. I haven't really talked about that. That's a different option. Many of the other patents that we talk about they're more about the utility of something, defining the apparatus itself or method of using it. Design patent is specifically about the ornamental design. So for example, if I was, had some designer purse, that would be something that someone would probably go for a design patent on, because it has a specific ornamental design to it that makes it stand out and be valuable. But actually, the purse performs the same function as purses before it, so it wouldn't be eligible for a utility patent. Okay? My point of showing some of these different claims is, actually the next slide will show this a little better. Remember the wood splitter that I talked about, the hitch hatchet? This is in one of the first patents I filed. It's basically a method for splitting wood comprising the steps of. And so this outlines how you would actually use it. You would get the wood splitter, you slide it into your hitch receiver or your vehicle, you put a log on top, and you smack it from the top. Now the advantage of having a claim like that is that that device that's used there could be designed many different ways and still infringe this method patent. Whereas this here is an apparatus claim, and this is for a splitting tool, but it describes the physical attributes of that tool. Okay, so it could be designed many different ways. You could have various designs for the tool, but only one would, well, one that broadly fits into these, that have these attributes would fit here. So, does that make sense? I don't know if I made that clear enough. All right, so after the patent examiner does their searching and examines your claims, the examiner will issue an office action. And basically the office action is saying essentially that. I've studied this, and here's my conclusion. If they like your claims as they are, they'll issue a notice of allowance, basically saying, good, you pay your issue fee, and then your patent will become issued and active. They may do what's called a restriction requirement. And this comes up quite often. It essentially is stating that, hey, there's more than one invention in your patent application or your claims. And it would be a burden on me, the examiner, to study the art for all these different inventions. So what they'll do is they'll restrict you to only pursuing one of those inventions at a time. If you wanted to go after another one of the inventions, you would have to submit another patent application just for that. Okay. Then there may be objections where they say, well, I don't like the wording that you used, things like that. 102 rejections. Remember I said there was 3 things that they look for. 102 rejections, basically saying it lacks novelty. 103 is unobvious, or it's obvious in light of the prior art. And again, they can combine references to come up with that. So once that comes in, we basically have 2 or 3 months to respond to it. And we can pay for extensions if we want to, but it costs extra. And I can either point out errors to the examiner's arguments. And this actually happens quite often. The examiners are under time pressure, so they'll make, what do you want to say, very bad rejections where it's like, what are you talking about? You're not even making sense. And so I'll have to go through and say, what you're saying does not make sense for the following reasons. And that's not unusual. But it's not unusual for an examiner to come back with a rejection after you submit a patent application, just because I think they feel like they're doing their job if they reject you right away. So you have to kind of understand what the game is that's going on. Yes?
When would you choose to file 2 separate patents on the same concept?
So basically, it all depends on the claims. So if you're, like for example, that method claim and the apparatus claims, okay, those are in 2 separate patent applications. Okay, if I tried to combine all of those in one application, they probably would have given me a restriction requirement. Okay, so in this particular case, I actually went after method claims for different embodiments of the invention, but it happens a lot. In that hitch hatchet patent application, I have like 300 drawings for various ways that this can be done. So it's hard to get claims that would cover all of those. So I actually go after various embodiments in different patent applications. Does that make sense?
So you put 300 drawings in with your application?
Mhm. So, yes.
I would just say, I'm loving the discussion, that there's so many questions, because there's so much going on with this topic. I know we were at time, but we still have the space. I just feel like maybe now would be a good time to just kind of morph into the Q&A, and we can answer questions from there. Does that work for you, Brian?
Okay. Actually, let me just shoot through just a couple more of these.
Absolutely.
And see how quickly I can go through them.
Perfect. I want to make sure everyone's questions get answered, folks.
Okay, and sometimes with the office actions, these arguments can go on for a while. So, but as long as you're willing to pay the fees, this is a request for continued examination. You can continue to argue with them, and that happens sometimes. Basically, after you get everything allowed, you pay the issue fee, and then there's maintenance fees after issue at 3, 7, 11 years to keep the patent application or the issued patent alive. All right. Just a few tips for, trying to save cash. Some other patent considerations. Okay. A few important points. It's really important to keep your invention confidential, okay, until a patent is filed. The U.S. is a first-to-file system, which basically means that whoever gets to the patent office first has the rights to that patent, to that invention. Okay. So with that said, the U.S. Patent Office does allow a 1-year grace period. Okay, after you disclose something publicly. Okay, but there's still a chance someone will file before you. So the point is make sure you get your patent application filed before you start going public. I also mentioned about using confidentiality agreements. I've been in a lot of meetings where there's been confidentiality agreements. There's also a lot of times where people are saying in these meetings, well, I'm under confidentiality, but I can't say much, but Joe over here is actually working on XYZ. And so they help, but they're not going to save you. So I wouldn't rely on them. It's important to do patent applications well for a variety of reasons. And then here's some things regarding cost. And actually, I think, one last point. Okay. I want to make sure everyone understands there is a difference between patentability and right to use, okay? And I tend to look at it this way. Basically, I'm tired. I think I used Julia in this case. She's tired of going down to the river to collect water in her hands and getting a drink. It seems really inefficient. She says, you know what? If I invented a bucket and went down to the river, I'd be able to scoop up the water, carry it in my arms back to my campsite. Okay, great. She files a patent application on it. She gets a patent granted for this bucket. Okay, Emily comes along and she says, you know what? If I'm going to go down to the river, I want to carry 2 buckets. I'm going to invent a bucket with a handle on it. All right? So now Emily submits a patent application, gets a bucket with a handle, patent on a bucket with a handle. And the question is can Julia add a handle to her bucket invention? Well, she legally can't because Emily has that patent. She has a patent on a bucket with a handle. But what a lot of people get confused about, can Emily sell her? She can't, because Julia has a patent on the bucket, and Emily has a bucket within her invention, okay? So the point I'm trying to make is that Emily's invention here may be patentable, but she may not necessarily have the right to use it, okay? And so all of this gets into diving into prior art, making sure you know what other patents are out there and whether you're clear for right to use, okay? So, all right, I think that's it.
Thank you. Thank you. Loved all the questions throughout. That's exactly what we want in these types of formats and events. But we still have a few minutes if you all have more questions. I know Brian is a wealth of knowledge, so please raise your hand. There you go.
Yes.
Evan.
Yeah, so I have a question on the topic of provisional patents, and then expiring after a year if you don't file for a non-provisional. So you say that they'll expire. What does that entail? Can you not use those claims again, or can you not patent that idea?
No, okay, so the provisional patent application is just an application that gets sent to the office and it gets a filing date, okay? And it expires after a year no matter what, okay? It doesn't even have to have claims, okay? So what, it's not unusual, for example, to not introduce claims until you file a non-provisional patent application, okay? It's just that you can't claim the benefit of the provisional patent application in your non-provisional unless it's filed before expiration of the provisional. Does that make sense? Yeah. Okay. If you file the non-provisional the day after it expires, there's no continuity, and so you basically have established for yourself a new filing date. So you essentially lose, someone may have filed a similar invention 6 months before, and then you're in a higher position. So,
Thank you.
yeah. Yes? Yep, Joe.
Yeah, so one thing I want to talk a little bit about, if you don't mind, is don't be discouraged just because you go to research your patent or your idea or your invention, and there's other things that have IP are similar. The other purpose of the Patent Office in its inception was to create a database or repository of inventions so that you could improve on those inventions. A lot of times entrepreneurs, when they get out there and they say, I want to patent this thing, and they say, oh, there's all these patents that are similar to my patents, oh, I'm dead in the water. But actually looking at that and looking at unique ways to patent around or create your own little landscape, like Brian said, with the information from the Patent Office is also can be very valuable. There's actually people that actually go and research patents and say, I want to patent something in this space, and they look at all this patent landscape, and they say, okay, I can now patent this. So I just want to say, a lot of times we've noticed in the past that entrepreneurs, they go to patents and they get discouraged quickly when they say, oh, there's a bunch of patents in my do a patent search. But it's actually a really useful tool for you to look at those existing patents to then find a unique way to kind of reinvent or tweak what you have to make it unique, and then you can patent it. So don't be super discouraged, because a lot of times you come back with your original patent and you get a patent research and there's 30, I mean, Jake, how many were yours? There's 30 or 40 other things that are similar, right? And you're like, oh, now I'm dead in the water. But actually it's a tool for you to use to find a really unique way to then work around that, to then invent something that is novel.
Yeah, it's not unusual to dive into, say, a patent search report. And as you start scanning all the patents, all the prior art that's there, to say, oh my gosh, none of these are touching on X, Y, and Z. So in a lot of cases, I look at those search reports as sort of inspiration to say, what else can I come up with? Or what didn't they think about? And so when I talked about the solar window, for example, that's basically what I was finding, I was looking at all these coatings and everyone's working on the perfect coating, but no one was really addressing, well, what do we do with this coating after we invent it? And I said, okay, that's the intellectual property, or that's the space that I'm going to fill. And as it turns out, 5-6 years later, a lot of companies are starting to file, and I'm before them, so it's a good thing. Questions? Yes?
Do you have any advice for collaborative inventing agreements before brainstorming and developing those designs, and how to maybe plan ownership of IP in advance?
Yeah, it's a little tricky because I worked in the medical device industry, and we dealt with a lot of orthopedic surgeons that weren't the most humble people all the time. And so you would have these collaborative work sessions, and everyone kind of thought that I came up with that, and the thing is when we file a patent application, not only is the inventor obligated to sign an oath saying, hey, I'm the first one to invent this, I also have to make sure any knowledge that I know of, I can't file a patent application if I know someone else was involved, or it's not really the person that's filing. So it gets really tricky, and what I would say is if you're going into one of these brainstorming sessions, I would probably take my knowledge or your knowledge and put it into a provisional patent application and file it. And so later on, basically, if there's any questions, you can say, hey, this is what I have on file. I have a filing date, and just so there's no dispute as to what's mine and what someone else came up with. That's probably what I would suggest.
One other method you can go through too, if you're going to do collaborators, you want to disclose the IP. I mean, you have to, on an intellectual property application, you have to disclose all the inventions. That's by law. You have to do that, because you're obligated to do it. And sometimes in the operating agreement of a business, you're going to generate an LLC or a business. In the operating agreement, that then you can determine in that agreement who owns what, based on you negotiating that with somebody else. But I do agree with Brian. If you have intellectual property and you go to me like that, first off, you want to make sure and disclose it to the patent office and meet your date. Second, you want to have a non-disclosure agreement with people in that setting. It's clear that says that we're going to have discussions here, and the things that I've listed here are mine now. And anything that we co-invent from the year forward, we will then identify where that intellectual property goes from that point forward.
Okay, makes sense.
Yeah, let me just add one other thing is that as you're moving forward, there's inventorship isn't determined until you figure out what claims are going to be allowed, okay? So you may have, say, 5 people that file a patent application, they're all listed as inventors, but maybe 4 of those, the contribution of 4 of the inventors turns out that there's prior art against it, and there's only 1 person. You're actually supposed to amend the patent application so that only refers to the 1 inventor whose claims are left. And it gets a little tricky because you don't know that until after the patent is allowed. So the other thing that we run into is there may be people that direct others to, hey, I have this idea for something, and they take it to some engineers, and the engineers work on it like crazy, and they figure out how to make it work. There's a fine line between, is that work inventive? Who actually invented? Because the patent's all about invention, and that's who gets listed on the patent. The people that may put 1,000 hours into tweaking it, that's not necessarily invention. if they're just sort of doing the technical analysis and tweaking, machining and manufacturing of it. But a lot of times those people are really hurt if they're not included on the patent. So, but it doesn't work that way. So it creates some issues.
I think we have time for one final question.
Yes?
Where I work, we have a lot of design ownership. Is that the same as having a design patent? And when they transfer design ownership to another company, is that basically like a patent transfer?
Well, I'm not sure exactly what you're speaking of. When I talk about design patents specifically are for the ornamental design of something, okay? So I don't know what the product is that you're...
So at Resolve, they have medical instruments patented by their customers that they make, but also Resolve owns some of their designs, right? Like you said, the medical screws.
Mhm.
I've heard that designs can transfer from company to company because a lot of them do make the same sort of stuff, so they transfer it in order and different contracts and stuff. Is that a transfer of patents at all?
Yeah, so most of the stuff that you're talking about are not design patents. Okay, these are utility patents. And basically the people at Resolve Medical, or I think some of it's been transferred from company to company. Basically there's either a licensing or an assignment that occurs. So an assignment, basically, if Pioneer Surgical owned that patent, they would say, okay, for X number of dollars, we're going to completely assign that to company B. Okay, that patent becomes just like selling your house. It's now has a new owner. When we talk licensing is different. They're basically saying, okay, we own it, but we're going to allow you to use the technology that's included in this patent application. Okay, so it stays with the owner, but it's just licensed, basically like renting somebody's house.
Okay. Thank you.
So, yeah.
Let's give another round of applause.
Thanks, everybody. Appreciate it.
All right, I'll just stay down here. Thank you all for coming. I hope you had a great experience. I know I personally learned a lot, and thank you for all the analogies. That was really helpful for me. Just a reminder, our next Tech Talk is January 12th. Mark your calendars. We'll be hearing from Ben Vandenbroek about 3D printing, and that's at the Peter White Library. There's a QR code on your program, so scan that or visit our website. As I mentioned, we'd love to hear your feedback on how tonight's event went, so also scan the QR code to fill out a really brief survey. I swear, it's only a few questions, will take just a few minutes, and it's really valuable for us to just keep improving our events and put on these types of events for all of you. But really, I want to thank the ORDOC and Kelly and the incredible team here for hosting us. This is a great time. And thanks to our amazing student team at Invented and Wheel. This event couldn't have been possible without all of their support, so thank you. With that, thank you for coming. Drive safe, and hopefully we'll see you again soon. Thanks, everyone.